Welcome to LiveLaw. I'm Sanya, back with part 2 of the most important judgments of Supreme Court of India. I will be going over 15 of these judgments today. If you want to go over the first 15 judgments I covered in this series, click on the link in the description box below. Supreme Court issued slew of directions to implement video conferencing in all courts across the country. Highlighting the immense need to observe social distancing alongside unhindered access to justice, the bench issued a slew of directions in order to streamline the functioning of courts via video conferencing. This was done by top court in its suo motu case. Governor can direct floor test even while House is in session, Supreme Court said while approving MP Governor's decision. While hearing a petition filed by Shivraj Singh Chauhan and other BJP leaders seeking immediate floor test in the MP Assembly following the resignation of 22 Congress MLAs, the bench held that a governor can direct floor test even while House is in session. The court therefore affirmed its order passed on May 19 to hold floor test in the MP Assembly for proving the majority of the previous government led by Kamal Nath. Free COVID testing only for persons under Ayushman Bharat scheme and EWS categories. Supreme Court had allowed private labs to charge others in modification of its previous order directing free testing for COVID in both government and private laboratories. So what the court did was it directed free testing to all persons eligible under the Ayushman Bharat Pradhan Mantri Jan Arogya Yojana as already implemented by the Government of India and any other category of economically weaker sections of the society as notified by the government for free testing of COVID. 100% ST reservations for teacher posts in scheduled areas unconstitutional. Constitution bench held in this case that 100% reservation of teachers belonging to the scheduled tribe category at schools situated in scheduled areas is constitutionally invalid. The bench also quashed the government order issued under the hand of Governor of the state of Andhra Pradesh, which had affirmed absolute reservation for scheduled tribe teachers and imposed costs on both Andhra Pradesh and Telangana governments, seeking reasons from these both state governments for breaching the 50% ceiling in reservations. NDPS, quantity of neutral substances in mixture, must be taken into account with actual drug weight to determine small or commercial quantity, top court held, while overruling an earlier 2008 decision titled E. Michael Raj versus Intelligence Officer Narcotic Control Bureau. Bench held that the quantity of neutral substances in a mixture containing narcotic drugs or psychotropic substances must be taken into account along with the actual weight of the offending drug while determining small or commercial quantities under the NDPS Act. Deemed university covered under Prevention of Corruption Act. Supreme Court held that a deemed university will come under the ambit of Prevention of Corruption Act 1988. Bench set aside a judgment of the High Court of Gujarat which had allowed the discharge of trustees of a deemed university from prosecution in a corruption case. The apex court observed that the High Court was in fact incorrect in holding that a deemed university is excluded from the ambit of the term university under Section 2C11 of the Prevention of Corruption Act. Article 30 doesn't prevent state from imposing reasonable regulations to make administration of minority institutions transparent. Supreme Court upheld the validity of National Eligibility Cum Entrance Test, which is the NEET for admissions to medical and dental courses. Bench further restated principles governing minority educational institutions under Article 30 of the Constitution, noting that the right conferred on religious and linguistic minorities to administer educational institutions of their choice is not an absolute right and is not free of regulation from the state. A citizen must have some standing or knowledge before questioning capability and integrity of a judge. Supreme Court held 3 people guilty of contempt for making scandalous allegations against judges. Bench noted that a citizen must have some standing or knowledge before questioning the capability or integrity of the judges of the highest court, and cautioned that the right to criticize judgments delivered by any court, including the Supreme Court, does not encompass the right to question the bona fides of a judge or to raise questions with regard to their competence. Sarfrazi Act applicable to cooperative banks, a constitution bench of top court held, stating that cooperative banks under the state legislation and multi-state cooperative banks are banks under section 21C of the Sarfrazi Act. The bench unanimously held that the Parliament had the legislative competence to bring cooperative banks under the ambit of the Sarfrazi Act. It thus rejected the argument that 2013 amendment to the Sarfrazi Act adding multi-state cooperative bank in section 21C 4A was a colorable exercise of power. Sabarimala reference. Supreme Court gives reasons for holding that questions of law can be referred to larger bench in review. Top court passed an order detailing reasons for reference of questions of law to a larger bench in a review petition. The 9-judge bench headed by Chief Justice S.A. Bobde had dismissed objections regarding the maintainability of reference in Sabarimala review petitions on February 10. On that occasion, the bench had stated that it will give reasons for the conclusion later. So it had then given out the following reasons. Number 1, limitations in Order 47 of the Supreme Court rules are not applicable to orders, judgments in writ petitions. Number 2, reference can be made in a pending review petition. Number 3, no matter is beyond jurisdiction of Superior Court of Record. Number 4, Article 142 justifies the reference. Number 5, not necessary to refer to facts to decide pure questions of law. Number 6, Article 145(3) proviso that reference to a larger bench can be made only in appeals and not in any other proceedings is not applicable to references made by a bench of 5 or more judges. Supreme Court refused to pass orders for 4G restoration in Jammu and Kashmir, asked special committee to examine issues raised by petitioners. Top Court directed constitution of special committee comprising secretaries of union ministries of Home Affairs and Chief Secretary of Jammu and Kashmir to examine contentions raised in pleas seeking restoration of 4G internet in Jammu and Kashmir. The bench observed that even though the court recognized that the union territory had plunged into a crisis and the court was cognizant to the concerns related to the ongoing pandemic and hardships, there was a need to ensure that national security and human rights are balanced. India's freedom will rest safe as long as journalists can speak to power without being chilled by a threat of reprisal, Supreme Court said in a writ petition seeking quashing of FIRs filed by Arnab Goswami. Top Court said that to allow a journalist to be subjected to multiple complaints and to the pursuit of remedies, traversing multiple states and jurisdictions when faced with successive FIRs and complaints bearing the same foundation has a stifling effect on the exercise of his freedom. The bench further reiterated that decisions have held that the right of a journalist under Article 19(1)(a) is no higher than the right of the citizen to speak and express. But the society must never forget that one cannot exist without the other, and free citizens cannot exist when the news media is chained to adhere to one position. Patent illegality, a ground available to set aside domestic arbitral awards made after 2005 amendment. Supreme Court observed that an arbitral award can be set aside under Section 34 of the Arbitration and Conciliation Act if it is patently illegal or perverse. A bench observed that the ground of patent illegality is a ground available under the statute for setting aside a domestic award made under the 2015 amendment to the Arbitration and Conciliation Act. suo motu extension of limitation or lockdown will not affect right of accused to default bail. Supreme Court held that its suo motu order extending limitation and lockdown restrictions of the government will not affect the right of an accused to seek default bail under section 167(2) of the CRPC. Holding thus, the bench set aside the judgment of a single bench of the Madras High Court in S. Kashi versus State, which had held that the time to file charge sheet under section 167(2) CRPC will also get extended on account of the SC order, extending limitation and the lockdown restrictions. Supreme Court nullified post-March 31 sale of BS4 vehicles, barred registration of such vehicles. The Supreme Court recalled its earlier order of March 27, which allowed sale of 10% of unsold BS4 vehicles for 10 days after the lockdown in areas except Delhi NCR, after noting that the automobile dealers sold such vehicles during the lockdown in violation of the order. Following the recall of the order, the bench held that such vehicles sold during lockdown should not be treated as sold and that the consideration received should be refunded to the purchasers. The court also ordered that no such vehicles sold after March 31st should be registered. Thank you for watching. I hope this was informative for you. Stay tuned for part 3. Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.